Good afternoon, and thank you for joining us. This is Bill Karsten with Plan Pilot. I will be flying solo today, but certainly know that other members of the Plan Pilot team are here to support you. Honest truth is, I think maybe I got selected for this is because all of my teammates know I don't have a dog at home, so you won't have to hear barking in the background. But first, I just want to point out, I got a question about getting linked into the PowerPoint. So we are running this as a webinar, so some of you may be signed in so that you can share my screen and I'll go through the presentation. If you have not done that, if you've just phoned in, know that we're just following the paper, the document that we sent out to everybody, which you should have received on Friday afternoon. So first, just best wishes on behalf of everyone at Plan Pilot to everyone who's joined us today. I hope you're staying healthy, both physically and mentally well. I know it gets to be more of a challenge as we spend a little bit more time in isolation. So we certainly wish the best to all of you. A little bit of housekeeping. Just know that we are taking questions that we will reply to after this webinar. We're not going to try to reply on the spot. But we will take in everybody's questions, share those with all attendees, and also provide the answers to those questions, some of which, honest truth is, may require a little more research, which we'll talk a little bit about today. This is an unusual circumstance where we have legislation that went from a path to enactment immediately, and so there's still some interpretations going on, and despite our best efforts on research, we're still seeing some inconsistencies, which is something that I'll certainly point out as we go through this today. So we're going to cover just very specific areas of the CARES Act, which was approved by the Senate on Wednesday, the 25th. It was approved by the House on Friday, the 27th, and then fairly shortly thereafter signed into law by the President. So step one on our behalf, recognizing how quickly that these provisions are being implemented was, we wanted to be quick in getting this information to you. And obviously, as you can tell by how quickly we got the document out, we cheated a little bit. And we had the document ready to go, but we didn't want to send it out until it actually had been passed into law. And then we went ahead and scheduled this webinar to share what we know and where we don't have 100% certain answers, we will be clear about that as well. But again, know that two things. One, we're taking in questions, so please feel free to enter those during this webinar and you'll get responses post-webinar. And we also stand ready to schedule one-on-one calls with you after this webinar. So where are we at right now? We've conducted extensive research, first and foremost, importantly, reading the Act itself, or at least the sections pertaining to retirement plans. We won't pretend we read all hundreds of pages that cover areas outside of the retirement plan. We've participated in numerous webinars, read papers, gone to online resources from reputable law firms, record keepers, and the like. And so again, with that, we see there's some certainty and 100% clarity in some areas, but unfortunately there's some other areas that are open to interpretation, and so we won't try to get to a definitive answer there until we can do some more homework on that. So again, today's session is focused on CARE Act provisions that are pertaining to retirement plans, but we will quickly address two other provisions under Title II of the Act, which Title II, it's 2 out of 6. And Title II addresses assistance for American workers, families, and businesses. So just a couple items that we thought would be of interest to everyone. The first is unemployment benefits, and recognize that these are also subject to state guidelines. But this act provides for an increase of $600 per week above customary amounts through July 31st of 2020. And regular unemployment benefits may be extended all the way through the end of 2020. Do note that there was a concern expressed by several congressmen that, as we understand, was not addressed in this act before it was approved, where there was a concern that the unemployment benefits may pay out at a higher rate than certain employees' regular wages would. And so, looking into that, we see that those provisions may be revisited more to come on that potentially in the future. The second item before we get into the retirement plan provisions are the tax credits, which we've all heard a lot about. $1,200 for single filers, $2,400 for joint returns, and $500 per child. Now, there are income limits to receive the full amount of these checks, which are, well, I shouldn't say checks, they should be direct deposited. And it's $75,000 income limit to get the full amount for a single filer, $150,000 for joint, and $112,500 for head of household. And there are phase outs above and beyond that. So, there are people who potentially will receive a portion of those amounts, but not all. So again, really quick for people who joined late, I just want to reintroduce myself again. It's Bill Karsten with Plan Pilot. As I mentioned previously, I am flying solo today, but certainly know all members of our team are here and prepared to support you. So feel free to reach out and schedule a discussion at your convenience. So now moving forward, and I will skip past this executive summary page and go into the provisions. So there's three areas of focus related to the retirement plan provisions. First is the waiver of required minimum distributions. Second is corona-related distributions. And third is corona-related loans. The RMD waiver and the corona-related distribution guidelines are more straightforward and easier to apply. You'll see with regard to the coronavirus-related loans, they carry additional considerations and may be more challenging to administer, and I'll go into that as well. From what we see, and we do see consistency from several sources on this, is that all three of these provisions appear to be optional. And but do know that different record-keeping providers are addressing this in different ways, and I'll talk a little bit to that near the end of this webinar. So first, with regard to the waiver of required minimum distributions. So bear with me on the technical language here. We're going to Title II, Subtitle B, Section 2203 of the CARES Act, and I apologize if at any point I call it the Secure Act. I am meaning only to talk about the CARES Act today. And this applies for 401A or 401K plans, 403B, or individual retirement accounts. And these rules of waiving the required minimum distribution apply to first-time 2019 RMDs that were to be made by April 1st of this year, 2020, which I recognize they passed the act March 27th, and we've already almost gotten to April 1st. So the truth is, a lot of people may have already made those required minimum distributions. But it also applies to any 2020 RMDs, and that includes first-time 2020 RMDs that technically would not need to be made until April 1st of 2021. Those also can be waived. So for those who are interested, this also, again, includes IRAs and inherited IRAs, which really the effect is, the waiver makes it as if the year 2020 never happened. Many of us may wish that were the case, the way the year is going so far, but in terms of saying that it's as if the year never happened, basically would just that the individuals would be able to skip that year relative to making a minimum distribution. So in that regard, looking at the considerations, if a plan sponsor wishes to adopt this provision, that's one that should be easy to administer, and we don't have any reason to not permit this. Moving on to the second provision. So here we're looking at coronavirus-related distributions, Title II, Subtitle B, Section 2202A of the CARES Act. And basically, coronavirus-related distributions apply to 401A or 401K plans, 403B, and IRAs as well. So just a little background on this, though. Recognize that your plan may have distribution guidelines in place, which are at your discretion in terms of what you permit for your plan. So some other in-service distribution guidelines that may or may not be in place would be for an age 59 and a half in-service distribution, hardship withdrawals, distributions due to disability, rollovers. A lot of plans permit rollover dollars into the plan to be rolled out at any time. And then most recently, the Secure Act, and yes, right now I mean to reference the Secure Act. There was the recent addition of the qualified birth or adoption provision for up to $5,000, which again, that was something that's optional for you to be able to add to your plan. So, this is a new category of distributions that may be permitted where you could allow a distribution in an amount up to $100,000. So what's interesting with regard to, if you do permit these distributions in your plan, you'll see at the bottom there's a note that the plan can rely on the participant's certification of satisfying one of the qualifying events, which we noted a couple in this paper here. I'm going to actually tell you a couple others that we didn't include because we don't think they really apply to any of our clients. But first, the first one, the CDC approved test. My apologies, left out the what that acronym stands for. That's the Centers for Disease Control and Prevention. So it has to be, although it's self-certified, a participant ought to be able to, or needs to be able to later verify that someone was diagnosed through a CDC approved test with COVID-19 or spouse or dependent, and then the second item you see there, or they experience adverse financial consequences where you might have more people fall into this category rather than the first item. Other criteria, being unable to work due to closing or reducing hours of a business owned or operated by the individual. So you can see why we didn't necessarily put that in here. But one other that's a little bit more of a potential future catch-all is or other factors as determined by the Secretary of the Treasury, which is Steven Mnuchin. So there's potentially more to come here. So we just point that out. Also, going to the considerations, just one of the three I want to highlight, that this distribution provision permits distributions through the end of this year, December 31st. And just recognize, and we'll say it again as we get into the loan guidelines, that the new loan guidelines only apply until 180 days after the CARES Act was enacted. So according to our math, that's September 23rd, 2020. In case somehow that's calculated differently, we put in the words on or around, but it should be into fairly late into September. And so again, going back to saying you can rely on a participant certification, that is clear. And we have read that language in the CARES Act. There's actually a specific clause that states that you can rely on an individual certification. We do not see that language relative to loans. However, we have seen some out there, whether it be legal experts, record keepers, we have seen some interpret that certification also applies to loans. We do not read that is clearly spelled out in the Act is the same way as it is for distributions. So I guess more to come on that. We'll all have to keep an eye out for that. Moving on to the next page, those that are following your own document, we're on page 3. Continuing the discussion on the coronavirus-related distributions. Just a couple of points here. Clearly the biggest thing is that an individual could distribute up to $100,000 under this provision. And you see the list of guidelines here. It is not, these distributions would not be subject to the 10% early distribution tax. And then, interestingly, the second point, note in the parentheses, the plan sponsor is only responsible for verifying whether a participant has exceeded $100,000 in plan distributions. And that does apply to all employer plans, including plans maintained by employers in the same control group. But where that gives you leeway is it's not, as a plan sponsor, it's not your responsibility to determine if the participant has come to you for a distribution that in aggregate with their IRA distributions would exceed $100,000. That is up to the individual to police that. The fourth item, I just wanted to add on to that, which we know, distributions are not subject to 20% tax withholding or the required notices. However, unless a participant opts out of withholding, there would be 10% withholding that would apply. But again, apparently a participant can opt out of even the 10% withholding. And then the sixth item, I just want to identify that, here it says at their election, participants have up to 3 years to repay the distribution amount through contributions to any retirement plan or IRA. And that can be multiple contributions made over time. So for example, if someone took out $50,000 in the first year, they could put back 10, the second year 10, and they still in the third year could put back another $30,000 to fully restore those dollars without a tax consequence, which in essence, it would be treated as if they had done a direct rollover. So in essence, they're greatly relaxing the standard 60-day guidelines that are normally in place. But it's also important to recognize that's above and beyond their normal limit. So, you look at the current year, the limit for an individual is $19,500. If they took a distribution and put $20,000 of that back, that in no way impacts their ability to contribute up to the separate $19,500 maximum. So moving forward here to coronavirus-related loans. So before addressing the coronavirus-related loan provision, the first question is, what are the significant differences between distributions and loans? And so the first one, which itself has a question surrounding it, as I pointed out earlier, is relative to employee certification. So for distributions, it's clearly stated that yes, you can read it in there. You go to the section that deals with distributions. There is a section that clearly states that employees can self-certify. We just don't see that for loans, and so more to come on that. We're not sure at this point if that was accidentally left out of that section. But at this point, we certainly are not able to give clear guidance that employees can self-certify on loans. The second difference would be loans. You could have a 5-year repayment period, plus a year allowed for suspending payments. Home loans could be, 10 years versus, if you're taking a distribution, you only have 3 years to repay the distribution before it's a fully taxable event, in essence, that you couldn't restore those dollars. And then a third difference, which is down in the consideration section, is that potential complications related to the plan's loan guidelines. So again, reading through the Act at this point, it's pretty silent as to how to apply a plan's current loan provisions. I have heard some experts of the opinion that you still have to live with the loan guidelines within a plan. Here, we just don't feel at this point there's 100% clear guidance. So we carefully put in the words that, as you see in the second consideration, participants seeking a coronavirus-related loan may still be subject to the plan's loan guidelines, and that would include number of loans, available loan sources, active versus terminated, and so forth. So that's just something that we'll have to navigate through. And again, that's just part of what comes along with this legislation being passed and put into place so quickly. Everybody at this point is scrambling to ensure that, or try to interpret this legislation properly. One additional item for any loan, and this is over at the guidelines, in the middle there, for any loan currently outstanding, the due date of any repayment due in 2020 is extended by 1 year. That's the one section of this guidance here that we, or this act that we see as required. And, we've referenced several legal sources on that, and there does seem to be agreement, whereas whether or not you enact the coronavirus-related loan provision is optional. This particular section of giving that 1 year extension is a requirement. Interestingly, one other item, I mentioned the 3 provisions which we've now gone through. There's an additional item that basically says if the Secretary of Health and Human Services has declared a public health emergency, which occurred actually on January 31st, retroactive to January 27th, that the Secretary of Labor then would be authorized to extend the due date for any ERISA required filing by 1 year. So potentially more to come in that area. The Secretary of Labor, in essence, has the green light from the Secretary of Health and Human Services, but to this point, we have not seen any specific extensions that have been put out there for the retirement plan notices. I mean, as you may be aware, within the legislation, we're extended till July 15th for tax filings. There are some other things, but we're focused here today specifically as it relates to your retirement plan. So moving forward, in terms of actually amending your plan. So again, I'm intentionally here referencing the SECURE Act and not the CARES Act. Many of you may be familiar that they're extended. There's an extended time allowed for formally amending your plan relative to changes that are going into effect, because there are some mandatory changes relative to the SECURE Act. And as it states here, plans have through the last day of the plan year that begins in 2022 to amend. That same guidance applies to the CARES Act. And so for those of you with a calendar year, that have your plan year on a calendar year, you have until December 31st of 2022 to formally have your plan amended. For a plan, for example, that had a June 30th year end, you'd actually have all the way until June 30th of 2023. So, no worries about a rush to amend your plan. First is really around the decision of which provisions to permit in your plan. And so I promised I would talk about what guidance we've received from record keepers, and know that Plan Pilot, our consultants, we have reached out to all of your record keepers, and we've gotten some responses. Some have maybe even issued you guidance in terms of how they will implement the CARES Act provisions, but know that this will not necessarily be the same for each record keeping provider. For example, we've seen guidance from both TIAA and Fidelity that they intend to go with negative election, which basically means they intend to apply these new provisions to all of their clients' plans unless the plan sponsor indicates otherwise. So, that's the reason why we were in a hurry to get this information out to you, and why we wanted to hold this webinar quickly, even though, unfortunately, as I pointed out, there's a couple areas that we're still seeking some additional guidance on. Do know that you stand to be negatively elected into these provisions unless you give other guidance with certain record keepers. Again, I just identified a couple who have indicated that, which again was just TIAA and Fidelity. Others that we have reached out to got back to us quickly on Friday, but indicated that the truth is they're still assessing how they're going to go about applying these provisions. So know that situation may be different if you're with a different record keeping provider. So that's really all we had to share today. I hope you found this to be informative. Again, I just want to point out we value your questions. Please provide us those questions. If you didn't get them in today while this webinar was going on, please follow up with me, Bill Karsten, or with your consultant or any other member of the Plan Pilot team, and we will be compiling all of those questions, reviewing them carefully, and getting back to everyone provide them everyone's questions as well as answers to those questions. And also, most importantly, know that we're all here for you. You know, although they had me fly solo today, honestly, because it was the easiest way to run this webinar, a lot of the team members listening in intently right now, and everybody stands ready to serve you and to address your questions. So once again, I just want to say thank you for joining us today. I wish you all the best in staying healthy. And again, I really mean it, both physically and mentally. Challenging times ahead, but we look forward to connecting with you and helping you in any way we can. Thanks and take care.